Welcome to the Berenzweig and Leonard podcast about the Supreme Court. We're in the BL Media Group's podcast studio. My name is Clyde Findley. I'm an attorney here at Berenzweig and Leonard, and I'm also here with a colleague named John Polk. He's an attorney also at Berenzweig and Leonard. And we're going to talk about a case that's coming up before the Supreme Court in a couple of days on March 4th. It's about abortion, but we're not going to talk about that. We're going to talk about a legal issue called standing. And we may get on into the little bit related to abortion, but not much. We're going to mostly talk about standing. So, John, why don't you just tell us what this case is all about and why we're here?
Sure. The name of the case is June Medical Services versus Russo. Russo is the Secretary of the Department of Health and Human Services, I think is the correct title, in Louisiana. And what the case is about is a Louisiana statute. Louisiana enacted a law which says that an abortion doctor must have what is called admitting privileges at a hospital within 30 miles of the abortion clinic. Now, admitting privileges means that the doctor is on the staff of the hospital, has the authority to admit people to the hospital and to perform surgery there. So Louisiana enacted this statute saying that abortion doctors have to be within 30 miles of a hospital where they have admitting privileges. The action was brought by an abortion clinic and two doctors, and their argument is that this requirement is an undue burden on a woman's right to get an abortion, and the result of it is to limit the number of abortion doctors and the number of abortion clinics that are available for women to get abortions. Now, there are a number of issues in the case, but I think the most interesting one does concern what we call the doctrine of standing, which is another way of saying who has the right to sue. Because in this case, there is no woman plaintiff. There's no woman who has come forth as a plaintiff and said, I wanted to get an abortion, but because of this law, the nearest abortion clinic has closed down and I have to go 300 miles or 400 miles to get an abortion, and there are only a handful of doctors left who will perform abortions because of this requirement. There's no woman in the case like that. This is being brought by the abortion clinic.
Right.
And by the two abortion doctors. And what they are doing is they are asserting the constitutional right of a woman to get an abortion. Under the prior Supreme Court decisions, a woman has a so-called liberty interest under the Due Process Clause to an abortion, with certain limitations, but right, to an abortion. So the question is, why should the abortion clinic and the doctors be allowed to assert somebody else's constitutional right? They have no constitutional right to an abortion. Yeah, none.
Yeah.
And they're asserting what is called third party standing, is what they're claiming. But that is fairly limited. In order to invoke that, they have to show that the person who has the constitutional right, namely the woman, can't assert the right, has a real impediment to inserting the right.
That's the hindrance.
Yeah, the hindrance standard, and that doesn't seem to be the case here. Women could
easily have filed a lawsuit.
Sure.
Yeah.
And then there also has to be a close and special relationship between the person filing the lawsuit and the person who has the actual right. Mm-hmm. In other words, there has to be a special relationship between the abortion clinic and a woman who might want to sue for an abortion. And that's questionable whether that's true in this case as well. So the Fifth Circuit did find that the plaintiffs had standing,
right,
but the state of Louisiana has brought that issue to the Supreme Court. And I think that's the most interesting issue because it could have significant ramifications, not just on abortion cases, but I think on a variety of other cases, and it could drastically cut back, depending on how the court decides it, it could cut back the third-party standing doctrine.
Let me jump in and ask a kind of easy question. And why can the Supreme Court address the issue of standing now, so late in the case? Why isn't standing already decided? And I think I remember reading that standing in this case can be waived. So is that true? And why is the Supreme Court looking at standing anyway at this level?
Well, I don't think standing in this case can be waived because standing is considered, if it's Article III standing, which is what we're dealing with here, Article III of the Constitution, standing is a jurisdictional requirement. It's related to the case and controversy requirement.
Mm-hmm.
And unlike what is called prudential standing, I don't think that, my understanding is that Article III standing cannot be waived. And the reason it's in the case is because it was dealt with at the Fifth Circuit, and the state of Louisiana filed a cross petition to raise the issue before the Supreme Court, and the court took the issue.
Right, the court took the issue.
Yeah.
So what's the difference between Article III standing, what is that, and prudential standing?
Well, Article III standing has basically three elements. A person has to show that they suffered an injury in fact,
Mm-hmm.
which is fairly traceable to some action by the party they're suing,
Right.
and it's capable of being redressed or remedied by a judicial decision. And if they can show that, they generally would have Article III standing. Now, prudential standing is different, and it's questionable whether it's a good doctrine at all. My understanding of this is that it started in the 1930s when the Supreme Court and other courts were looking for ways to discourage a lot of litigation attacking New Deal legislation. And so they came up with this doctrine of prudential standing, which allowed the courts to get rid of some of those cases early on. And the basic elements of prudential standing are that the litigant, the plaintiff, has to show that he or she is within the zone of interest
Right.
of a statute. So Congress enacts a statute, and that statute is intended to protect some class of people's rights, some rights. And to have prudential standing, a person has to show that they're within the scope of the people that Congress intended to protect.
So in this case, if we're going to try to apply the prudential standing standard, the zone of interest is arguable that maybe it's just the women who are intended to be protected by the statute. The doctors, the health clinic, is going to have to argue that that zone of interest is broader, that it includes the doctors as well because of the close relationship between the doctor and the patient. That's the idea?
Well, you're right. The statute in this case certainly was not intended to protect the clinics or the doctors.
Yeah.
It was intended to protect the interests of the women, to make sure that when they go to an abortion clinic, it's a safe place. It's run by competent personnel, and that the doctors are competent.
So that, I think you're going to argue that that's true even though the doctors may have a hard time, really hard time, being able to actually perform the procedures because of the statute, because of the requirements of the statute. So you're still going to maintain then that the statute is about women and not about the doctors, when the doctors are the ones that are going to have to satisfy the standard in the statute.
Well, I think it's clear that the doctors are not within the zone of interest being protected by
By
the statute.
By the statute, okay.
But recently, more recently, the Supreme Court, some justices on the court, have called into question the whole prudential standing doctrine as to why do they have it. And in particular, in a case 2 years ago, the city of Miami versus the Bank of America, that was a case where the city of Miami sued under the Fair Housing Act, sued the Bank of America for all sorts of damages, claiming that the lending procedures of the bank violated the Fair Housing Act. And Justice Thomas wrote a concurring opinion saying this doctrine of prudential standing is really no different than the question of whether the plaintiffs have a cause of action under the statute. It's the same as, do you have a cause of action?
Okay.
And so why bother with prudential standing? The question is, do they have a cause of action or not? And the Supreme Court's decision in that case, it was one of these cases where obviously they did some horse trading behind the scenes, because they didn't get rid of the doctrine of prudential standing, but they wrote an opinion which made it so hard for the plaintiffs to show that they had a cause of action under the statute that Justice Thomas, in his concurring opinion, says, why don't we just stop with this foolishness? They can't prove a cause of action under the statute anyway, but the court sent it back down to the lower court to give them a chance. So the question I think you're probing is, where does prudential standing here?
Is it still alive? And if so, could it cover the doctors?
Well, it's still alive, but I don't think it's relevant to the doctors, because they clearly aren't the ones within the zone of interest. Unless I think their case depends on being able to convince the court that they have this third-party standing to advance the constitutional rights. Not a statutory right here. It's a constitutional right under the Due Process Clause. Enforce the constitutional right of women who want to get abortion, even though they don't have the right.
Right.
Now, if you stop and think about some hypothetical cases.
Go ahead.
Let's suppose a state enacted a statute which said any shooting range must be at least a quarter of a mile away from any other building or any public road. It has to be a quarter-mile radius around it. And the effect of that state law would be to shut down more than 95% of the shooting ranges in a state. And a private company that runs a shooting range sues and says, and sues on the grounds that they are trying to advance the Second Amendment rights of gun owners.
Of gun owners who no longer can show up and go to the range because the range is shut down.
Right. They argue this is an undue burden on Second Amendment rights.
Right.
And they're trying to advance the constitutional rights under the Second Amendment, in this case, of gun owners. Well, should they have standing to do that? It's an interesting issue.
It's an interesting question, and I think it's almost exactly the same as in this abortion case.
It's very similar. And I also suspect that many of the same people who would urge that they're standing in this case, the June medical case, would probably say in my hypothetical, "Oh no, there's not standing."
Right.
And you can think of other other situations where let's suppose there's a company that's in the business of writing and implementing affirmative action plans for companies, and a company makes a decision to dispense with affirmative action plans. They decide they're not going to have them, and the company that authors and implements these plans and sells them as a contractor to a company tries to bring a lawsuit saying, well, by abandoning your affirmative action plans, you're having a disparate impact on certain minority groups, and they're suing on behalf of the rights of minority groups. Well, should they be able to do that to advance somebody else's rights? Generally speaking, in our legal system, people can only advance their own rights, the rights that they hold. So the question is, what's the court going to do with this third-party standing issue?
I think, based on what you said so far, you're about ready to predict that the Supreme Court could overturn or I guess uphold the Fifth Circuit here, but on a different issue, on standing, and basically clarify the standing rules of the court to basically only be judicial Article III standing, jurisdictional Article III standing versus prudential standing, and then invalidate the Louisiana law on that basis.
Well, I think they could.
I'm sorry, uphold the Louisiana law on that basis.
Indirectly uphold it. I think that what they could do to duck the really significant third-party standing issue and having to really grapple with it, they could conclude that in this case, June Medical and the abortion doctors simply don't satisfy the requirements for third-party standing.
Okay, rather than getting rid of prudential standing or whatever, they could just say, in this case, it doesn't apply. They don't satisfy that standard because they're outside the zone of interest.
Well, I think what they could say is that there isn't the close relationship that the doctors and the clinic would have to have with a woman who wants to have an abortion. There isn't that type of close relationship.
There's no real hindrance because a woman can easily file a lawsuit just as easily as the doctors can.
Sure. And in this case, not only is there a special close relationship between the plaintiff as a third party advancing the interests of the person who actually has the right, but it seems that the rights are perhaps in conflict because the purpose of the Louisiana statute, and I think you've mentioned this already, are specifically to protect the rights of women, not the abortion clinics.
Right.
And the Fifth Circuit did hold that there is some benefit to to protecting women from this statute. Now, that gets us in, of course, into another issue, which is that the district court, which heard the case, initially found that the Louisiana law did not sufficiently advance the health interests of women, and it didn't serve a particularly useful purpose along those lines. And the Fifth Circuit did something which is rather unusual for a court of appeals to do.
Right. They looked at the facts differently.
They looked at the facts and they made their own factual findings contrary to some of the findings of the district court.
Right.
And generally, a court of appeals only should do that if they find the district court's factual findings to be clearly erroneous.
Clearly erroneous, right.
And the Supreme Court could dispose of the case that way and say, the Fifth Circuit went way out of bounds in what it did. And so I think it's very difficult to predict what this case is where it's going.
Do you think it's possible to do both? Or these are two different viewpoints that are really so far separated from each other that the court would not touch both issues at the same time?
Well, if the court decided if they decided the case based on the Fifth Circuit's improper overriding of the district court findings,
the district court.
Well, it would. I think it would probably just result in a reversal. But
okay.
But I'm not sure that the court would. If the court did that, then I don't think they would reach the constitutional issue. There's a doctrine of constitutional avoidance, and I think they wouldn't reach out to this other issue involving third-party standing and Article III standing and so forth.
But so isn't standing one of these qualifications in order to bring a lawsuit anyway? You got to look at that issue first. You can't get to the merits unless you really talk about standing first.
Well, actually, yes, you're actually right about that. And so I suppose that would be true. They may have to reach it
to talk about standing
because Louisiana brought that issue before the court.
Right.
The Fifth Circuit decided against the state of Louisiana.
Right.
They may not be able to duck that issue. You're right. They might have to deal with it.
So in terms of the court wanting to address the issues of abortion more directly, they don't even have to do that at all in order to dispense with this case. They could just dispense with it on standing grounds and force the doctors or the clinics or to go find a woman if they wanted to refile. And so the case could be completely dispensed with on just standing grounds without hardly even touching anything relating to abortion. Is that?
I think it could be, and even if they go into the issue of whether the statute creates an undue burden or not, they still wouldn't be, I think, addressing the fundamental issue of a woman's right to an abortion. I don't see that this case is presenting that issue.
Yeah,
I think it presents. When you look at the case, it depends on what perspective you take. If you look at the case from the abortion clinic and the doctors, and perhaps from women who want to have abortions, they see it as a case bearing on their
Yes.
right to have an abortion, and this statute creating an undue burden.
Right.
But if you look at it from the other side, Louisiana will say, this is simply an exercise by the state of Louisiana of its regulatory power over healthcare providers. And we're not doing anything different than the regulations that we impose on ambulatory surgical centers,
These
for example.
outpatient clinics that their doctors have to be admitted in the local hospitals as well. So
Yeah.
this is no different than that. And that's their argument.
Yeah.
That's what Louisiana would be arguing.
And that's an argument that the Fifth Circuit agreed with. The district court didn't, but the Fifth Circuit did. So it's a very interesting case, and it'll be interesting to listen to the argument, because abortion cases always seem to produce some fireworks somewhere,
Yes, they do.
and it could be a very interesting case.
So this has been a very interesting discussion, and we know that the Supreme Court is going to have a hearing on this case in just 2 days. So we're going to probably be back here again to talk about the outcome of that case. And so we'll see you later. And thank you very much for listening and watching.